Good morning, everyone. I'm very grateful for everyone who showed up and who's interested in this topic, which is very, very timely. I think all of us know exactly why we are here and why we need to discuss this. We are starting now, so I think that if everyone who was still in the back would like to catch a seat. So I'm really happy to have this panel here and remotely connected as well, a colleague who will present via the remote connection. My name is Anja Wirobeck. I'm working in the European Parliament for MEP Birgit Sippel, who some of you might know from the rapporteurship on the e-privacy regulation, as well as e-evidence regulation and other files. She's notably also the coordinator, so I'm here currently speaking, not in this capacity, but in not representing the European Parliament. As you know, all the disclaimers are necessary. On the panel, we have fabulous speakers coming from various fields. I would like to encourage all of you to immediately ask questions, to jump in from the beginning. If you hear something that you don't know, if there's an acronym, and we are infamous for that you are unfamiliar with, or if you have input on something that one of the speakers, including me, say, please immediately jump in. I'm trying to see you as best as possible. Unfortunately, there is no mobile microphone. So if you ask your question, speak up. And I will paraphrase it in a shorter sentence. Just as well, please refrain from having like monologues disguised as a question. If there is something you would like to say, please let's put this outside of this panel. Or if it's super urgent, then keep it short at least. And with that, I will just quickly run you through the order of the talks. I will start with a short setting the scene. Next up, we will have Christina talking. Then we will have Felix jumping in with civil society and solution-oriented talks. Then we will have Malte.
Me.
No, Malte, no.
First
you, exactly, because Malte will react from the Commission's perspective on what he has heard from us and obviously what the Commission is planning in order to address the issues with the withdrawal of the e-privacy regulation. And with that, I'm happy to start by basically just very, very simple scenario. You go on a website and what you see first, it's not content, it's a question. And the question is, do you accept cookies? And sometimes it's very simple, it's a yes or no question, and you are not even deceived by that, but more often it's a maze. It's a pop-up, it's a slider, it's hidden toggles. The fine print is endless. Perhaps you have already consented your firstborn child away. It's death by 1,000 clicks. So can we call this meaningful consent? I'd say no. This is yet to be determined. There is no definitive answer on this. However, at the moment, what we can definitely state is that there is a lot of consent fatigue. It's a systematic erosion of our attention, our time, and ultimately also our digital dignity. And I think that one thing that we have to set out straight is that privacy is not a luxury, it's a right. And it is time we started to treat it that way. We've taken the tool, the cookie, and by now, cookie is the overarching term here because they are the tracking technologies are manifold. That was once used to remember your login or conveniently your shopping cart, and we have weaponized it to track and to profile and monetize users across the web. Today, privacy has a price tag, and not metaphorically, but literally. Many platforms now offer a content pass, pay with cash or your data. Is data a commodity? The message is clear though, your personal data is the product. But not all data is treated equally. Should your decision to reject personalized ads be treated the same way as trying to prevent fraud? I hear this a lot from the telcos. Is knowing whether someone clicked an article as intrusive as knowing where you sleep, what you earn, what your mental health or state of health is? Less intrusive purposes like security, debugging, or fraud prevention can operate with safeguards and trust, and not default exploitation. Whereas targeted ads and behavioral tracking require real, informed, uncoerced consent, not dark patterns and paywalls of privacy. And where pseudonymized minimal data becomes the norm and not exploitation. You've probably done this 100 times already this year alone, and you're not alone. Actually, there is a survey from 2023 by the Norwegian Consumer Council that found that 8 out of 10 users accept terms without reading them. So blanco. Why? Because modern consent mechanisms are broken. They are opaque, manipulative, and utterly exhausting. Today we will explore how we can address the widespread problem of opaque and deceptive consent practices and the growing epidemic of consent fatigue. This issue isn't just technical or ethical, it's ultimately solvable. It sits at the intersection of law, computer science, user design and behavioral economics, but also exploitation for commercial purposes. Consent is meant to empower users, but in practice, it often disempowers them, undermining the very principles of autonomy, transparency, and trust in primary law and the GDPR or e-privacy framework that strive to uphold these. It concerns every publisher, vendor, and edtech company like Meta who collects user data, everyone who builds user interfaces, and every policymaker concerned with digital autonomy. What's at stake here is not just convenience, it's privacy, confidentiality, and to a certain extent, even national security. Cookies and similar tracking technologies silently exploit users by monitoring browsing habits, behavioral patterns, and communication metadata, often without meaningful consent. This undermines the confidentiality but also integrity of digital communications. Whereas governments and private actors can purchase metadata from data brokers to survey entire populations bypassing legal safeguards. Law enforcement agencies have, in the past, in documented cases, used such metadata to investigate completely innocent individuals. This is also a threat to the presumption of innocence. Recognizing this, the EU Parliament has strongly advocated for a strengthened e-privacy regulation. It was, back then, a long-awaited complement to the GDPR, and the e-privacy regulation aimed to tackle exactly these issues. And I'm not going to present any kind of secret here if I say that from the European Parliament's perspective, we were quite advanced on finding a solution to these kind of issues, in particular the consent fatigue, in particular to how to tackle the end device intrusions by data that is being extracted from it or emitted from it. However, it takes two to tango, so the Council was not convinced that the solutions on the table were workable, and therefore, ultimately, the Commission has decided to withdraw the e-privacy regulation in its program from this year. Well, we're very curious to hear how this decision came about and what the path forward is. What I would like to talk today about is not only the legal regulation, so what is the legal setup, but I also want to talk about the technical standards. So we need to have legal regulation that must be clearly enforceable, and as we all know, we can't go against one vendor. If you have one cookie out of 900, how do you enforce against that one vendor? So the legal regulation must be clearly enforceable and set out clear requirements for the data usage for the processing. But we also have to talk about technical standards. There it becomes very interesting because all of this is not a secret. We have some solutions on the table. We have two different forms that will be presented today. And ultimately, if we have the time, we will also address the TCF judgment that the Belgian Market Court just ruled on last week, exactly. And I would love to hear your questions, your thoughts on this, because all of you are end users. All of your communication, all of your interest is represented in what will be on the table, what is at stake. And therefore, this is not just something that we are discussing in a theoretical realm, but this is very, very practical. It concerns your fundamental right to privacy and your confidentiality of communications. With that, this was basically just to set the scene. If you already have a question, feel free to go about it. Unless there is a question, I would give the floor now to Christina, who is connected to us remotely and brought also a presentation that our kind colleagues from the venue.
Thank you.
All right.
Thank you very much. Wait until okay. You can see my slides?
Yes.
Yes? You can?
Yes, we can.
Yes.
Okay, perfect. Okay, so again, thank you very much, and thank you for having me here, especially virtually. It became a bit challenging to arrive.
Christina, I'm sorry. We already have a question from...
It's not a question, it's just a comment. I think the screen that you are showing is actually the PowerPoint, and I think you are on a different slide that we are seeing. So
Christina, which slide are you currently... Which slide would you like to show right now?
I'm showing the OC and the work on consent.
So perhaps you have to... Could you change something in the presentation so we see whether it moves?
Oh,
Because we are seeing the CPDP front page.
Still the first slide. Yes, perfect.
Now it has changed. Yes, now it has changed.
Okay. So
Thank you.
if they're not in the slide mode, the power presentation mode, I don't know, they didn't move. Okay, so now you see the next slide. Okay, thank
Yes.
you so much for that
Thank you.
intervention to whoever. other speakers. And thank you.
Thank you, Christina.
Thank you.
Yes, it's great to see you now, and not just a presentation. So are there immediate, I mean, I have tons of questions, but yes, please.
This is going back to the global technical tool on the opt-out system that you spoke about in the
Christina,
US.
do you hear?
No.
Okay, then I will try to paraphrase. So it's concerning the technical tool.
Yeah, so it said that the user opts out in the website and then a signal gets sent back to the website, and I just
It's about the opt-out via the website.
Yes, and I wanted to know if this is a signal only for just that one website, or if this, you could say, like a persistent cookie that stays in the
Very good.
the- and then if that is applicable to any other website that would come in
Mhm.
with similar cookie banners. So by default,
Mhm.
this user is not interested in any
Mhm.
cookies in any website. So is that a standard blanket application, or does this?
Very good question. So I don't know how much you've heard. Otherwise, I will just try to paraphrase. So the question was whether the opt-out that the user is signaling, what value does this hold? Does it go across all websites? Does it go across the network of this website? What kind of recognition does this choice, this signal have? Does it basically apply to all websites, or does it fade? Will you be asked again?
Yeah, so basically, this specification can be integrated into web browsers to enable browser opt-out. And when it's activated, it sends HTTP header to websites and sets a JavaScript object in the document object model, indicating the user's preference to opt out of information sharing. So it is through multiple websites. This is why it's done once, and it doesn't require repeated actions from the user. And this is its advantage, let's say.
Thank you.
Please.
Wasn't it at some stage Article 10 of the e-privacy regulation, and are we now trying to get it back via another means?
Yes, and so Article 10 of the e-privacy regulation was drafted in a time where we did not have gatekeepers yet, and where the combination between browsers, and we know now that certain browsers do have a position as gatekeepers, were, I would say, more benevolent. We looked at them a bit differently than we look at them now. So in the course of time, there was also understanding within the co-legislators that Article 10 could not be upheld the way that it was drafted by them back then. But indeed, the idea was already then existing. So we are building on the latest state of the use, and not only art, but it's exactly that, indeed. One more question, and then we have to give our kind panelists also some time. Yes?
So basically, I actually wanted to ask on this content management on the website side of things, because to me, I'm wondering, why don't we have this already? Because to me, it seems like it's so transparent. And for example, you can also achieve some granularity that, for example, overall, I want this and this, but I can give some exceptions for specific websites.
Mm-hmm. So on the question,
This already.
I'm wondering. You want to answer this?
No, I think I will.
You will answer this. Okay, so Felix will get to the bottom of this, but indeed, I mean, there are plenty of. There's a need for this, and there's actually a communication between the website and the browser, respectively the cookie banners that we have. And if they all spoke the same language, then this would be possible, but they deliberately do not speak the same language. But more details from our colleagues on the panel. And now I'm going to I'm going to give Felix the floor. Do you wish to use this mic or this mic?
I think I would use this one if that works. Yeah.
And he will present us the ADPC and the underlying corresponding standard.
Yeah. Thank you for having me. Yeah. Okay. I guess I would need this. Yeah. So thank you for having me. It's a pleasure to be here. I'll speak about ADPC. That means Advanced Data Protection Control, and that is a standard to communicate privacy decisions of users. So basically a little bit what you just asked for. And okay, we also heard in the previous presentation by Christina that there's already such tools like Do Not Track or GPC, for example. What's the difference between ADPC and these tools? So let's have a look here. ADPC has more options compared to Do Not Track. For example, Do Not Track has two options. Either you choose do not track me, or you don't choose that one. And the ADPC solution has like opt-in, opt-out. You can define them per purpose. You can also define them per domain. So it's a bit more flexible and offers the solution that are required by EU law. For example, also this opt-in, which with an opt-out solution wouldn't really work under the GDPR, for example. Now, that's what it's meant to do, and as I said, it should be a standard to make things easier to communicate these privacy decisions. And how does that actually work? So yeah, it's also open for other legal systems, but that is just a side note. So the signal in itself, a website sends a request to a user, and then the user sends back what their basically decision was that they made in this moment or previously had already chosen. So that's how it works. It's pretty simple, and it's also lightweight and easy to implement. So that's one of the core ideas of how ADPC should work. Now some examples here. You can see, for example, if you open up the inspect function of a website, that's what you see. And here you have the example of do not track, and it's set to 1, and there's 0 and 1, as far as I know. And that's how that looks like in practice. And if you go to ADPC, then it sends a bit of a longer string. So it says consent to, for example, these two categories here. It says content recommendation and personal ads. So consent was given to these two. But now here you can see a bit what you asked previously. Thank you for the question, by the way. You can withdraw all previously given consent. You can object to direct marketing. You can also see that here. But you can then consent to 2 specific purposes. So it's a tool that's meant to be very specific and very good to implement and practical to implement for websites who actually want to obtain consent. Now, if you're a user, how does that look, or how may that look like? It's more of a standard, as I said, but this is one of the implementations, the test implementation. So if you visit a website, you might receive such a banner in a browser like Firefox, for example, and you see reject all, accept all. You have different options, can be granular. So that is one of the possible implementations, how it then looks like for users. And it's also kind of smart, whatever that means these days. But you can imagine it a bit like a spam filter. So you can, for example, set it up that it says, like, show me a pop-up only after every second time I visit the website, or only every 3 months, or learn from my decisions. So, or you can also, you can whitelist and blacklist things. So, for example, if you're quality newspaper, you can create a whitelist, and people can import this whitelist to their browser, for example, to their device. And by that way, that also ensures, it's a bit like an ad blocker maybe, that you can have different lists and can use different lists. So that is a bit the idea behind it. That's for the, let's say, practical aspects of how this is meant to work. And now let's go to the policy perspective, which is also maybe interesting for some of you. One of the important things here, there's no new rights, they stay the same. So it's a tool to communicate the decision of a user, but it doesn't really require any new rights or any change in legislation. It's more this standardization as a matter of protocol. And here you see the example. It's basically a little bit like email. So if someone can object via email, they can probably also do so with a different standard like ADPC, for example. Also, one of the benefits of it is it's less friction for website and website publishers in general. That means basically if I can previously choose I want to consent or I don't want to consent, then I don't have to make this decision all day, every day, basically. As you know, these days you're always confronted with cookie banners or pay your okay banners. So that's a bit like the idea. And of course, one of the things we tend to say internally is like the politician who killed the cookie banner will be remembered for the next 20 years. So less is more is a bit what my notes say here. I guess less cookie requests are better than more cookie requests. And previously, Anja already outlined why there's many issues with the cookie requests we see these days. And maybe because of this market court judgment here in Brussels, it's also a good moment to look into alternatives, because like the IUB system is fundamentally challenged. And apart from maybe standardization is also a bigger question, and I think this is my last point for today, if informed consent is ever possible with a system as such. And with that, thanks a lot for your patience, and yeah.
Thank you, Felix. Or I already see a raised hand. Go ahead.
How do we enforce that and monitor for violations?
So the question was for the recording, how do we enforce it?
Well, basically it would depend a bit, but if it's, for example, if such a tool, ADPC or something similar or comparable, was mentioned in some sort of regulation as a standard, then it could be enforced. Otherwise, of course, it would also, what could be a possibility is that, Google is probably the most prominent one, would implement this as a standard, or it would become a web standard. That would be a possibility, but I think it's not really, it's not so likely.
I disagree. Just for the discussion later on.
That's the question.
Yes, please.
Hello, so my name is Hugo, I work at Apple. So we enforce a system like that on the App Store. That's called App Tracking Transparency, which provides standard means for users to consent or not consent to tracking across apps and websites when you use an app on the App Store. And I'd like to add a key bit of context here, that we got a fine in March this year, just for that, for having deployed and enforced that system on the App Store.
I'm sorry, but this is not product placement, first of all, and second of all, I think the fine was not regarding the privacy settings that you had implemented, but with the preferential treatment that you are giving your own services in comparison to all third parties. I think that we should have a holistic, depiction of what is what the fine was about.
Thank you. I think I know really quite well. The idea was not to make product placement, but just to find this key bit of information which CNIL and all the DPAs themselves have brought out, that there's a tension between competition and privacy law here. And I just want to see how we also take that into account, because as we deploy those standard means, they're going to have companies unhappy with the standards, unhappy with the decisions, and unhappy with the enforcement. How do we back up the enforcement of such tools? Because at the end of the day, the idea here is to protect users and to avoid the consent fatigue and avoid privacy contact and make sure that, well, control over data processing is respected as is fundamental rights for users.
May I just pick that one
You
up?
have to paraphrase that.
I can't.
No, I think at the core, the question was how can we, I suppose, how can we create better competition for this kind of privacy enhancing tools? However, the core of the judgment was a competition violation, so it's a bit strange.
I will let everyone read the ruling, of course, and make their own decision here.
I think I cannot say much about the decision, but what I can say is definitely the consent mechanisms that exist currently are not a good solution, and I think we all know that. So it would be interesting to look into alternatives, and I think this is why we are discussing this here. And as you can see in these slides, which I didn't show you previously, this is already foreseen. It's just a matter of looking how to do that, and of course there's room for discussion on how to do it. But I would argue, like keeping things as they are just because a future solution might have, some cons, is not exactly the best way of dealing with the future.
I would like to pick that up, and I think a solution could be to put it precisely, a data trust or this data intermediary. So it's not up to Apple to make these decisions how to design these consent processes, but it's up to an independent, neutral entity. That might be a solution, but we will discuss this later on.
Yes, that's why I meant Article 10 e-privacy, the regulation did not have the very large online platforms or the big tech in mind, and who are currently in charge of both presenting you the content, being in charge of your preferences, and exploiting them for or against your goodwill. Yes.
Yes, so we know that the global privacy control is actually there to share the user preference only with the website that receives it, right? I don't want to sell or share my data, and I inform the website. And then it's the website owner or the website entity that has to actually inform everyone and say, okay, now this user doesn't want that. We know that in practice, it doesn't really work so well because we don't discuss what happens behind the scenes. So all these hundreds of third parties that are there on the website, they need to be informed efficiently about the user decision. And so my question to the panel is whether you know the current standards that are doing it efficiently, whether ADPC actually does that.
Can I, because also for Christina, I think this because it's also relating to her. Christina, GPC, how do we make sure that all the hundreds, like the whole, I would call the supply chain of actors in this, respect the decision of the end user, and all the 100 third parties are also informed about that decision? So I'm talking about the white sheep, so those who actually would follow this as well, but also the black sheep, like how do we make them compliant in case? And then the question to Felix in practical terms. I think maybe Christina wants to come in first.
It is not by no means a tool that we promote in any way. It's just an example that we've heard. It is a technical tool to explore. It is also an interesting case in terms of seeing how previous tools have evolved, and we now have the GPC because we had previous tools before. It is not a new technology. So I will take it to a more policy perspective, even though I know you want the technical answer, but I don't have the technical answer because the issues were also explored in the workshop and will also be reflected in our paper. But from a policy perspective, and answering to the previous question on how do we enforce it, and you've shown the articles on the GDPR and the privacy regulation. When it comes to the GPC and the US reality, we have the CCPA, so the California Consumer Privacy Act, which mandates basically to have they have clauses that actually grant legal validity of a browser-based opt-out mechanism, such as the GPC. So they basically had to implement some kind of tool, so this is why they came out with the GPC. So from a policy perspective, I think this is interesting to see. Now, from a technical perspective, I fully understand the concerns, but I think it's the reason why we should keep improving.
Thank you, Christina. Felix?
Yeah, just to maybe make that clear, standards like ADPC are not exactly meant for everything. It's just to communicate your user decision to the website. What the website does thereafter is a different issue. If they respect it, if they do something else, that's still, there would be need for some enforcement, or if they inform like third parties, but that's a different issue. Here, this is just about the standardization of how to actually communicate what the user wants or don't want. So that's the idea. So very, very simple in this regard, because in my personal opinion, I think you can overcomplicate things. If you make it too much of a big standard that should do everything, then maybe won't have a standard in the long run.
Just one. I'm abusing it, my position as moderator right now, but one aspect is that all the publishers should also look at who they're working with. So if you as a publisher decide for revenue purposes to work with 900 vendors that are shady, illegal, don't have any kind of compliance, and we are not talking about the technical or legal compliance right now, theoretical, but we're talking about laws that are existing, so GDPR and e-privacy. This is your choice, and you are abusing your end users when they visit your website. So if this is strictly just for revenue purposes, we should also discuss that aspect, because the publishers are the ones, gaining revenue through this illegal source or by using somebody who's illegally or unlawfully processing personal data. One more question in the back, and then we have to continue. I'm sorry, it's very intriguing, but you have to shout.
I'm happy because I get the chance. What typically took out was just said, so there's a division between the desires of the user and what's actually happening behind the screens. I do think this concept of
I'm going to break this down to a question: should we abolish consent? Is this like in a nutshell what we? So in e-privacy, there's not much choice. So in e-privacy, in the directive, we only have consent for cookies in this case, unless it's for different purposes that would not be relating now to the scenarios that we are discussing, not talking about technical or security purposes. In GDPR, we have different legal bases. So, but I will repeat this one more time: there is no legitimate interest in e-privacy. If you ever see a cookie banner with legitimate interest in it, illegal, fundamentally illegal. So I'm happy to hear from my panelists actually on this. I have a very personal perspective on this, but it would be interesting as a sort of wrap-up question, honestly, if after everything we've heard, whether or not consent has a future. If it's all right with you, I would keep this actually for the final round of considerations. I hope that's just to keep the pressure up. Great. Cool. So with that, I'm going to give the floor now to Max, who has a very interesting presentation to show us. I'm reminding him of 10 minutes speaking time. And so there's more for the discussion, and the floor is yours.
Yeah, thank you so much. I now need my slides. It's called Max. And I to confuse with the other Max. Exactly, yeah, Max Grafenstein. So as soon as I get my slide, I will press my button to count. Okay, cool. Yeah, thanks so much. So I would like to show here a research demonstrator we are building since 1.5 years now, based on ADPC actually, with a research grant from the German Ministry of Research. And this is, and we do this in order to test the effectiveness of different consent process designs. So there is a very important research methodological part, because we were developing since 2018 new methods, interdisciplinary methods, in order to do this effectiveness assessment by combining legal methods together with methods from user experience design and user interface design. And then we also combined that again with empirical methods, right, from behavioral economics, psychology, human-computer interaction research, etc. And this is very important because actually I think it is enforceable, because we have in Article 25, Section 1, this requirement that the controller, like the website, has to implement the legal requirements like transparency and user controls into her technical and organizational design in a way that this effectively protects against the risks, against the fundamental rights. And this effectiveness requirement is really important because from a legal perspective, this is really brand new, because it requires a lawyer to work together with other disciplines like UX and UI and empirical social scientists, etc., in order to measure, is this current implementation now effective or not? And this is why it was so important to us to develop these methods to do this assessment. So in a very first quantitative study, we tested whether a current cookie banner design designed according to best practice rules as recommended by the European Data Protection Board, whether they are effective. And as you already can guess, no, it's not, right? So more than half of the testers, they said they have no control over how their data is used. So I would say applying the law, this is a complete failure. Such a consent mechanism isn't effective. Then we went on, of course. We didn't stop there and really tried to develop new prototypes, using these new methods. And we were testing this again and again in qualitative studies and finally also in quantitative studies, of course. And the design principle, the design idea behind that is actually that we understand the consent mechanism not as a one-touch moment, but as a process. And this is very important because in the current situation, the user is asked in a moment where it's really the most stupid moment you can imagine. Yeah? Because you go to the website, you would like to do something completely different, but you are required to look in a very tiny banner to make a completely different decision, which is distracting you from your primary task. So the idea is to stretch that process beforehand so that you can make your preferences at a moment in time earlier, but also that you stretch it into a later moment when you're really engaging with the website and with the consent, etc. So in order to do this, we built this demonstrator universe. Yeah? It consists of several components, actually. So it is a consent agent, but then also a visual, a common visual interface in order to exercise data subject rights. It has a standard building up, again, on ADPC. It has also an enforcement mechanism. So we are currently building a certification mechanism through which you could actually ensure that all data receivers are really adhering to the conditions set in the consent. So this is the main idea, but I will now focus just on this very first component. And I would like to show you how it is currently looking. So you see this browser, it's my Chrome browser, and you see this little thing there next to the URL bar, this white thing. So this is the browser extension. And if you open this extension, then this is how it's currently looking. Configure your presettings once. We will hand them over automatically whenever you visit our website. And now you see that this is quite differently looking, right? So you have more explainable purpose specifications, improve the website with visuals, but most importantly, with this assignment of risks and benefits for each purpose. And we do this not alone, but again, in a bigger multi-stakeholder process where we ask different experts, hey, which risks and benefits would you actually assign to which processing purpose? And then we try to explain it in that way. And then you can also get other information. And on the fourth layer, you finally even get the legal text. Yeah? So the lawyer's readable layer. And then you can click through all the different tiles. Yeah, it's expandable. It's enable additional website features and customize the website for you. And always you see that the risks get bigger and bigger. And also this risk-benefit ratio, it gets worse. And this is very important because the end users are really using it, according to our empirical tests, as a very important indicator to make their decisions. So once you set your settings, you start surfing, you get to the CPDP website, and now you see this ominous thing, what we call a handover notice, right? So we say now, hey, we will send your consent in 19 seconds to this website if you don't want to change it. And this is very important. So the counter is 18, 19, 10, 9. So in the beginning, it's quite long in order that so that you can learn it, but it will get quicker and quicker. Yeah, the more you get used to it. But it is important to always give the user and also the website the possibility to change it, yeah, to adjust it to the specific case. And here, for example, I love the CPDP. I even give them all my consents, and then it is stored in the end in my consent agent. But of course, I can always open the cookie banner, and here you can see it's also adjusted. And I can now say, hey, that's so weird. The CPDP is processing my data for personal advertising. I don't like it, so I withdraw my consent, and then again, it is stored not only in the cookie banner, but also in the consent agent. So this is how it is looking. And I think it's quite different. Now let's come to the empirical test, because this is even more interesting, I think. So we run these ABN tests, right? The latest one was with over 1,000 testers in a longitudinal field study. And we have group A, status quo cookie banner. Group B, it's a cookie banner with this risk-benefit ratio. And then all the other groups are combined with consent agents in different designs. So we really test everything, what changes to have what impact, etc., on informedness, on trust, consent behavior, adequacy, etc. So, and now here you see the results. This is how well informed the different how differently the different designs inform data subjects about the risks, and you see that this is a bit disappointing. So you see in the very first column, A, this is the status quo cookie banner, and then you see that just slightly there is an improvement, right? E is even the best one, etc. And we were disappointed, however, it gets even a bit worse if you look at the negative, as a true negatives. As this is also very important with respect to the principle of purpose limitation, because the purpose specification is deemed that you can trust that no other risks occur, right? So now we ask the people, do you think that other risks occur, which are actually not there? And they start, the more information they got, they start fearing that even more risks occur which were not existent. So here it gets even worse, and only some, H and E, are equal to the status quo cookie banner. However, if you look at other figures, it gets really interesting because even just this very slight improvement leads to a massive change in consent behavior. Namely, you have here the status quo cookie banner. There, accept all 53%, deny all 47%. Nobody makes a granular choice. Just with this little higher informedness, there is an explosion of granular choices suddenly. Yeah, 65% for website improvement. I mixed it up, I'm sorry. 65% for website improvement, 52% for adjusting, for enabling additional features, 29% for personalizing the website, 27.5% for personalized advertising. So suddenly you have very granular choices, and this shows, I think, why we have to stick to consent. Because if you allow it all together, then you have this small amount of 35% who don't like it at all. And if you forbid it altogether, you have this 27% who agree to everything. So it would be a little bit paternalistic. Why do we think that this is why we have a chance to nevertheless improve it? Because we can really go into the details now for each purpose, for each risk, and we can find out where is the informedness low or high. And then we can really go into the details and improve an improvement. And that's not all, because we think also we have to expand it afterwards, and this leads us to this common visual interface recommended by AWO in their last study. And I just give you a very brief glimpse on it, how it's looking like. So this is a prototype for the European Commission showing the political targeting regulation in practice. Yeah? So you see this website and this political advertisement, and you click on this banner, and then you see, hey, why I'm seeing this ad? Because I'm a non-voter. And you click on it, because I'm male, 50 to 60 years, low income. You click, why am I male? Just imagine I'm a woman, right? So then I click on that, and I see, they get the data from Zalando, and because I'm always buying the stuff for my husband, they think I'm male. And this is really how it's going to work, right? So you can then go into your visual interface and then start deleting, correcting all the data. And we just think that with this kind, you can also exclude certain data receivers if you think they are untrustful. And I think with these methods, right, empirically testing and understanding it as a process, we are able to improve step by step, not yet now, but maybe in 3 years, to a level where we really have a new state of the art which must really be respected according to the law, to the GDPR, by all other stakeholders. And this is why I think it will be enforceable, and it will be the solution. Debatable.
Thank you, Max. This must be, I see tons of questions. First question from my side. Because people took pictures, and are you able to share the slides with the crowd? Because I think that there were so many pictures taken, and it would be easier for everyone if you could share that.
Yeah, of course. No,
so are they supposed to reach out, or is the organizers, is there a website, a platform for
yes, there is a website, and you always can also send me an email, and then I can show you everything.
So
what we have. And we will launch this thing anyway in July, August. Yeah, at least the first part of it.
All right, go ahead.
In the word of first-party identification, consent importance is amplified, right? So have you considered promoting this to companies like Trade Desk, who are, inventing the universal ID, and consent is going to be a key for viewing a website to be part of this?
Yeah.
Paraphrase the question, please.
Also, the question is whether we presented that thing to the industry. In the end, and we did, and I was surprised that even the actors which are deemed to be the worst, they are surprisingly open. Of course, it's a completely different question whether they are really doing it, because you have this hesitance to really adapt, because it's change, and change is always difficult. But I was surprised about the open reactions.
Go ahead.
It's a cool concept. I'll give it a try. But it doesn't have this magic component of being realistic. It's just sounds like another guideline from another body that suggests what are the good practices, and from that perspective, it's always great to follow a standard. But for this to be a success, the platforms will have to implement this.
Yeah.
And I don't see that flying.
Okay. Also,
The question, just paraphrase.
yes. The doubt is that this is realistic because it would only be implemented in practice if the big platforms implement it, and I don't think so. So what we do is something like Zuckerbrot and Peitsche, so the whip and the sugar bread. So we give this out for free, yeah? And at the same time, we combine it with a cookie banner blocker. So as long as the legislator doesn't show up and obliges the websites to really respect these signals, yeah, we enable the data subjects to block any cookie banner who is not respecting the signal. And this is quite convincing because just imagine what we are doing is we are turning the power relationship upside down. So far, it was the website publisher who was defining how consent processes are designed. Now we give that tool out, yeah, like ADPC out, to the end user. And just imagine we have suddenly 100 million end users using this thing, blocking everything away, which is not respecting their signals. I think industry will adapt. First of all, the publishers, and then it's also, so you really have to make it like you come from the right and to the left. So you have to convince, more or less voluntarily, the publishers, but also the advertisers. And then you get also the very messy middle block, namely the advertising tech industry. You make them adapt, yeah. But you have to first convince the beginning and the end of the whole data value chain, and I think it will happen.
One more hidden question in the back, and then we have to move on to hear from the Commission.
Hey, Jonathan, hi.
I just want to say an observation. You felt an elegant solution to trumping the tension between transparency and over detail, so that the user only has to explore once, set and forget. So compliments to you.
Okay.
That's nice.
That sounds like a coffee chat. So now we are here to hear from Malte, who will tell us how much he was inspired by what he has heard, and in particular what the Commission has in plans in order to react to the withdrawal of the privacy regulation, because certainly this was not a surprise that inevitably this was withdrawn this year. So the Commission is probably already working on a lot of new ideas since not just this year, but already in the past, and we are eager to hear some of that.
Well, how do I come in? I saw Paul de Hert in the back of the room before, and I was thinking to do a Paul Hert-style reflection on this, because it's a conundrum. I mean, there are so many things. We've heard the arguments here in the room. They've been exchanged. I've been on this case, I would say 11 years, when the first people came along and say, hey, I have the magic solution to recalibrate power solutions on the open internet. And they came as PIMs, personal data stores, consenter. There was even the people that says, could the Commission maybe be the first to implement a push cookie solution? So the website user actually pushes a cookie over to the other side. And well, so just to say, I've heard this a lot. In my previous work, it was mentioned, Christina mentioned it kindly, the Data Governance Act was mentioned. This is a bit what I gave to the world in terms of the power of intermediation of some sorts. If I can complement what Christina was saying, it's not about the cooperatives and the altruism. It's certainly about Chapter 3. And it's probably about Article 12 of the DGA. Because Article 12 has a very restrictive regime on what the intermediary can do with the data it means to be transacting. And I'm putting this up front here because I really want to advertise this also as a frame for the nice solutions that look nice because Max is nice and Felix is nice and the other Max is also nice and we trust these guys. But how are we dealing with a consenter from a not so nice platform? And I don't envy the colleague from Apple, and I don't envy the colleagues from Google who have market power at the browser level, at the advertisement tech level, and who have to constantly navigate between finding solutions, technical, that give people privacy without being caught for the competition. I don't envy anyone in here. So I think that's already an interim conclusion. Probably the legislator, even in the current climate, I'm looking at Anya, where there are people, I just was listening to Aura Sala, that say deregulation is the solution. I don't think so, because the companies that are navigating in these cliffs will always hit them, and they can absorb the fines. We can say, well, tough luck for Apple. I'm an Apple user, so all sympathy for that company. But it's going to be hard. So I think you can expect the legislator to take choices. How paternalizing it should be, how many things it should decide up front and say these are lawful things to happen in a world of online free content, the globalized web, etc., and how much choice we should give. That's a big conundrum. And that goes to the question that from the back on the role of consent. Consent will always need to have a role for certain things, because as consumers, we go to a shop and are able to make informed decisions. We also are able to make uninformed decisions to go gambling. But that's in a free society. There are certain things you will probably have to accept that people go wrong. Otherwise, the call for individual human empowerment is just not true. I think we have to, and that's maybe where I'm coming from, we have to navigate in a certain belief that with literacy growing, digital generations growing up, we'll be able to make certain informed choices. It's obvious that I cannot go through 772 third-party cookies. I cannot have an informed choice here. So here, other mechanisms have to come into play. But the thing is, also in this ecosystem, and I'll speak to the people that uncovered the data broker files. If you Google that, netzpolitik.org has done a tremendous research together with other news outlets on the proliferation, it was mentioned also, of our data going around the world and being able, with geolocalized tracking, to reconstitute personal movement profiles of people, because we are unable to enforce Chapter 5. We are even and not because it's across the borders. We're also unable to. I mean, I'm putting up myself here a bit exposed, but I don't believe that the DPAs will ever have the capability to run after each case of data brokering going wrong. So things will go wrong. I mean, I'm saying this here very publicly. Things will always go wrong. Relying consent will go wrong. Enforcement, things are going wrong. So this is a big conundrum. So when the file came partly to my desk, I had huge respect, because everything comes together. All the economic interest in tracking each and of us, consent questions, privacy, and data and competition also. It's a huge, and it's technically extremely complex. It's, for me, still a myriad of players out there. Each has a little role, and then the court judges here, and the court draws a screw here. Very, very complex. So yes, the Commission is reflecting on the future of the e-privacy directive as we have it, and trying to navigate in the broad era of simplification. So everything should be simple, but whatever that may mean. I think this is not a file where we should go simple. I mean, that's really, I'm putting this as my personal opinion out here, and that's also how we will discuss it in the House. And we have all sympathies for consent fatigue. And we all have an interest in the Commission, that is to reduce consent banners and the UI design. I think there is a lot to be said there. Will we regulate the way in which banners are presented? I'm not so sure you're in the capable hands if you give this to the Commission. I strongly believe that we need to find standardization. Am I out of my 10 minutes?
No.
Okay. No, I know Anja can be triggered quickly to intervene, but I will reserve my right to also expose my thoughts. I think we need a standardization for all of this. Are the mechanisms that we currently have with the capture that can happen in standardization committees ready for this? I don't know. I still will fight for this, because maybe just to round it off, just looking at my notes, also what I wanted to say otherwise, we will overloading the intellectual, mechanical capacity of the EU institutional system. I've been there. I've gave you also portability of IoT data. So it's complex if you want to do magic things, and this is a really complicated file. That's why I also probably grounded. One message is clearly separating things. I mean, taking the old directive, separate maybe the telecoms part from other things. Certainly that's a wish from our side of the Commission to separate law enforcement desires from the economic use cases, have separate discussions for whatever it's worth in different fora, in different committees, in Council and Parliament, and let the police minister justify what they think they need to justify, but let not overload the ship because it will sink otherwise. That's maybe my brief take on where we go. Otherwise, just to say, I really believe in the power of intermediation. That's why I invented Chapter 3 of the DGA, and I think we could frame it, this type of entity that runs the standards and managers in the same way. Last advertisement, the German lawyers know that you have Article 26 of telecom implementing law, e-privacy. You have a little kernel of legislation for that in Germany, and I think Max will benefit with his tool by registering as such an agent. That would maybe, there's a question. Yeah. No, it's maybe I can say you have an interest to use that legal framework to actually be subject yourself to a really strict legislation which says that you, Max, and your company may not have any economic interest in the transaction proper, but probably also not, that's the crux, in the volume of transactions. And that's really the thing with the PIMs that we've always been saying. Okay, I can understand DGA says the PIMs cannot have an interest in what the data transaction is about, but can it set wrong incentives to lure you into consenting to more things that you actually wanted? And that's a really hard thing, because at some point, also this kind of infrastructure needs to live. And I think in the current kind of separation of economic roles, it's not a good guess, even in a setting like this, to say, well, that's going to be the public, it's going to be a public digital infrastructure of some sorts in the Eurostack, if you want, because that's, I find it rather unlikely. We don't know. I mean, things are going on the Eurostack discussion. I would find it rather unlikely that a public body would take it on it in whatever form, foundation, whatever, to run either the, a user interface design like that, or even, maintain the standard, which will probably go in a, hopefully, a W3C setting anyway.
Thank you, Malte. I'm actually very pleased with what you have said, and I've made lots of points, and it's interesting to be happy with what the Commission is replying on these panels, because it was quite frankly very direct. And I'm not used to having such direct statements from the Commission. Usually it's a bit more opaque and bypassing. So can I just, because I know there are
just
also
a disclaimer, I mean, we are in a dark room under the earth.
Which is being recorded.
And I should, for the record, if there's any MLEX, your reactive or political person in the room, we are working on a solution, right? I mean, this is a thinking process that we're in, and that's really what happens right now. So all the things, there is no reading in between the lines what will happen at the moment. We'll come out with the data union strategy later this year, and in that document, I think that's our target, November, to announce at least in broad sketches what the future of privacy will be.
But then, if I understood you as well, sorry, I'm going to again shamelessly abuse this. In broad terms, you are not going to address the back end of e-privacy in the Digital Fairness Act, because it's the interface part. So anything that will be concerns the processing activities. I mean, for me, just like in terms of legal basis, it's impossible to include this into the DFA. But if I understood you correctly,
they have just launched They just launched their call for evidence. I think they are about to launch their call for evidence on the Digital Fairness Act. See what the scoping is that. But these are communicating bases, also with protection of minors from advertisement under DSA. There's obviously the gatekeeper rules. I mean, that's also why this file is complex for people like me, because you have to speak to a lot of teams inside the Commission. So we don't know.
Okay. So also you get a round of questions, please. Natalia.
Yes, thanks a lot. So I participated in the advisory committee of W3C, and I hear that W3C is really interested in talking more to regulators. So this was just maybe rather feedback to say that I think that both parties are interested, and maybe there should be more work together. Since you mentioned the standardization so actively.
Okay, this was again more a statement, but yes.
I haven't heard the term contextual advertising from any of you. Did we give up this idea and just accept consumer surveillance by default, or is this
still a chance?
I mean, the debate would get rather broad. I mean, we wanted to discuss actually the legal and the standards, so to say, setting. I mean, if we start talking about alternatives for publishers,
I don't think, also from the studies that the Commission has published on this, on the effectiveness, I'm not sure we're going to mandate either way, saying, no, you can never have it. Now, you also know the EDPP opinions on consent or pay. What I should share with you, what we hear is that in terms of the effectiveness, it's not the same thing from the other side. And it's also the question, would it lead to more capture by people who are better placed? We saw a Google starting page the other day, just before. What are you giving to these guys if you say contextual advertisement?
I would like to add something here. We proposed in our last study for the Federal Association of Consumer Protection Agencies in Germany our market approach. Because, but this was all, again, it's just a proposal. I'm not sure whether it's really working out, but if you would enable individuals really to compare different forms of advertising, so that they can see which kind of advertising makes the advertising really more relevant to them, because so far it's just a promise, but nobody can really verify it. Then suddenly you, and then you have consent rates according to this type of advertising, a certain conversion rate, and then the advertiser sector could choose according to this consent rate, conversion rate, and the price. And I would say that this is actually the ideal of a perfect market equilibrium if it work out. But for that, we need something like this, these mechanisms on the visual interface.
Last question before I ask you to wrap up, and Nick, it's you.
Yeah, my question is to the Commission. So, you mentioned a few things about like consenter, like setting up as a data intermediary and things like that. I'm just basically wondering about, so we have the right to object and so on and so forth. Like legally, it seems like tools like consenter and ADPC, like they're like legally sound, roughly, right? Not necessarily making like a judgment on whether they are or not from our point of view, because there may be questions. But like, how do we kind of like promote the adoption of solutions like that? Like what does it take from the Commission's point of view? Like, is standardization the only way? Is there like a space for guidance, for codes of conduct, or things like that? Like, if there is a solution that's like perfect from your point of view, how do we promote it? Also taking into account that like consenter and ATPC are browser-based solutions. We haven't basically not talked at all about like the mobile ecosystem, apps, and so on and so forth, except for Apple. So yeah, that's my question.
Just going to repeat for the recording. What do we need in order to promote these solutions that were presented today on the panel? Is it a guidance? Is it a code of conduct? Is it, anything that we have? It sounds like nothing. For me, it would be legislative, but what does the Commission think about it?
Well, that's the thing. Obviously, Article 10 of the proposal from 2017, and I was actually in the press room at the time, so it was very funny to see some journalists being very surprised that their Gmails were being kind of analyzed for very good purposes, obviously. And people learning that this was actually permissible under the proposal. So we'll go at all these things. On the cookie signals, that's indeed the question. Could you mandate, at least as one means, if a user has a browser extension that has, let's say, the consenter implemented, could you say you must comply? You must take the signal. That's the obvious thing. And then you can still see no one has the obligation to use a consenter, and people can still click and do the funny things. But that's obviously, from my personal take, an optimal outcome. That you say in a future e-privacy, well, we'll go into the discussion. We'll have to see, especially, for the reason that Anja mentioned, that we avoid the competition conundrum coming in. And that's Apple's problem. That it has a unique way to guide me through asking apps not to track, which I expose here. I normally do that because I find it convenient, but maybe with hindsight, sometimes I shouldn't. So, and then for the mobile ecosystem, I have not the technical solution ready, but obviously,
Yeah.
There needs to be the equivalent.
Exactly.
And I don't know what Max is doing for mobile. We're really in a web of 2004 discussion where, I mean, was also a happy person before my first smartphone, but obviously, I mean, that's then when, I mean, one of these PIM services comes into play and says, okay, or the two big ecosystems, or maybe the Chinese included, they team up and find a solution which we have to see, well, would be the duopoly solution in the world that is respectful of the design principles in one way. That's hard, huh? I mean, looking at the poor colleague who's now exposed, to enforce that, we'll have to see what the political weights. I mean, again, I heard Aura Salla, sorry for singling out, but she's also close in terms of Finnish and party politics to my commissioner. So I don't know what Henna Virkkunen will say on going after mandating in the Android ecosystem that you have to have an embedded, operating system level extension of all of this. I don't know.
Well, in a society or in a community where attention is scarce and exploitation is easy, we should also, this is not for today, have a discussion about these business models that are on top of all this. So I think that it's not so much the question of tool, but also whether or not these business models have a future in a fundamental rights-based society as in the European Union. But this was something that Christina mentioned, and I would like to give Christina the floor to conclude with her remarks first, and then unfortunately I see the room already emptying a little bit, so everyone gets more or less 1 minute in order to share their personal conclusion.
Or you just...
Or, but Christina, I mean, come on, please.
Yeah, just Christina.
So, very briefly, can I also make my concluding remarks on my slides? So, the first was the concern about standardization, benefits, challenges, and then basically the main concluding remark that keeps saying in the workshop as well is the complementarity of all these tools and approaches. We have to keep testing, we have to keep looking, we have to keep researching, and this is what the OECD does.
My panelists and to the technicians who also set everything up. Thank you very much. Have a lovely rest of CPDP and let's catch up over coffee.